Please. Hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning. Welcome to the December 11th, 2024 sitting of the Massachusetts Appeals Court. Sitting to my right is Justice Marguerite Grant. To my left, Justice Robert Toone, and I'm Justice Eric Neyman. We will be your panel on the first case today. After the first case, the panel will take a 2-minute recess. Let me repeat that. A 2-minute recess, at which time a reconstituted panel will come out on the bench. So that is a signal to all attorneys. Do not leave the courtroom after the first case thinking that you have time, because you do not. Usual appeals court rules are in effect. Each side has 15 minutes to present argument. There is no rebuttal. We have read the briefs. We have read the case law. We are familiar with your argument, so I would urge you to cut to the heart of your argument. However, your 15 minutes is yours to use as you see fit. Check with my colleagues. Anything further before we proceed? Wonderful. Calling our first case on the list, docket 24P579, Commonwealth v. SOTO. We will hear from counsel for the appellant. Good morning.
Good morning. Please the court, Adriana Contratesi for the defendant appellant, who is naturally very upset about his conviction, and it is difficult to overcome the presumption that when the trial court sits as fact finder, it instructs itself correctly on the law, and specifically as here on the admissibility of evidence. But despite the fact that the error was not preserved, the defendant still believes that he is entitled to a new trial on these convictions.
I just have one preliminary question, which wasn't clear to me. My understanding is our review on both of these issues is under the substantial risk of a miscarriage of justice standard. Is that correct?
Yes, Judge.
Okay,
yes.
Please continue.
Yes. I don't have a lot to say. It was a very brief trial, so there was not much of a record. However, I do want to refer to something that my sister will present, but I don't think she was the author of the brief, on page 15 of the Commonwealth's brief, that the sister's testimony was independently admissible to show her state of mind and why she went on to make the complaint to her sister. So this is the younger sister who testifies that she first complained to her mother, didn't think that the mother believed her, so she went on to text her sister at a party as to both of the sisters. And
I have a couple questions about that. This is to do with the record. Hello again. It's always good to see you.
Thank you.
One question is, do we have the text messages? I understand they were admitted as Exhibit 5 at trial, but I don't see them anywhere in the appellate record before us.
I can get if the court would like to have them.
I just want to make sure I wasn't overlooking them. My other question is, I see that the defendant's trial counsel filed a motion in limine that included the topic of first complaint. And I see that in the docket, but I don't see that in the record. So I understand there may be strategic reasons why what might count in some circumstances as first complaint might be something that a trial lawyer would not object to. For example, the fact that the victim said she told her mother and her mother didn't believe her. A trial lawyer might want that in. Do we have that motion in limine? Do we know anything about the lawyer's strategic reasons?
Well, we know that there was standby counsel in this case.
Okay.
There had been several lawyers. As I said, the defendant was very upset, and understandably, this case happened in 2016, and it really didn't get to the bench until years and years later. But I can provide those. But nonetheless, the Commonwealth's brief refers to this really inadmissible evidence. It only corroborated the first complaint. The second complaint only corroborated the first first complaint as state of mind evidence. And in that case, I understand state of mind evidence. It's used all the time, but in this case, I think it's overused. As to state of mind in first complaint, that is really meant to protect that one theory, and I know that there's many different areas of independently admissible evidence. There's many different reasons for additional first complaint testimony when it's independently admissible, is what I meant to say. But in this case, the state of mind issue really is meant to protect the defendant. For example, it's meant to protect the defendant, to allow the defendant to examine what the person's intention, the victims, immediately after the crime, what their intention was in complaining about the crime. So that is really meant to protect the defendant. The state of mind exception is just not applicable here, and there's no question that the second first complaint only served to corroborate the first complaint. And it did prejudice the defendant at trial.
So just to be clear, your position is that only the testimony about her telling her mother should have been allowed?
Yes.
And not the subsequent telling the older sister?
Yes. Well, that was the first complaint. And the mother, and the mother was not an irresponsible mother, and she knew the defendant, really this was such a subjective, I don't mean to be insensitive, but it was subjective.
This victim testified that the mother didn't seem to believe her, right?
Right.
So that's not very powerful evidence.
The evidence was not very
Commonwealth's case,
powerful
right?
at all.
I mean, that's right. So taking out the second piece actually.
Would have helped a lot. It would have made a huge difference. So it really was material. The final thing I do want to mention is I know the Commonwealth contends that, well, this was talking about the ice cream incident. Well, it wasn't talking about the ice cream incident because there was no touching described in the ice cream incident. So we know that this was all ascribable to the play fighting incident.
I just have one final question, and that's, how do you overcome the fact that this was a bench trial? I see that you cite to Darby, for example, but in Darby, there were 2 photographs that were admitted by the judge in a jury waived trial. They were utterly irrelevant and, in fact, quite prejudicial. And the judge stated on the record, well, they have some probative value. And so when this court reversed, it was because there was affirmative evidence that the judge improperly considered prejudicial, irrelevant evidence. In this case, I don't see any indication in the record as to the judge giving improper consideration to this evidence. So how do you overcome that distinction?
Right, and in the other case too, the Urkel case, was that Urkel? I cited another case too, where it was on the record.
Darby, Batista, and Urquile.
Right, so we don't have that benefit, and I think the reason why is that there was only standby counsel, that this was a self-represented litigant that had counsel been there, and again, this was a defendant that was very, very upset, and had counsel been there and had wits about him, it would definitely have been a different result. So if the court would give him a new trial, he could have a lawyer and get this corrected and have a chance to have a just encounter with the court. Okay. I don't have anything else, and I think my brief is comprehensive on the issues.
Thank you for your advocacy.
Excellent.
Oh, thank you. I appreciate that.
Thank you very much. We'll hear from the Commonwealth. Good morning, counsel.
Good morning. May it please the court, ADA Bryn Morse on behalf of the Commonwealth. I'm joined at council table by the trial prosecutor, Colleen Page, and I ask that this court affirm the defendant's convictions. I want to start with a clarification, and that is that standby counsel was acting as the defendant's counsel at both the motion in limine stage and throughout the trial, and so effectively the counsel, the defendant did have counsel here.
Do you know what the motion in limine said?
Yes, I do. I actually have a copy of it with me. The motion in limine said that we expected the middle sister to testify that she told the older sister first, and it also included a copy of the text messages, which are not particularly clear about the complaint, because if your honors remember, the first complaint testimony from the older sister was that the middle sister had texted her some confusing things and then had called her, and the entirety of the first complaint was those text messages followed by that, shortly after that call to the older sister.
What would be really helpful, I understand you didn't write the brief in this case, but under the appellate rules, in a criminal case, the appellee can file a supplemental record appendix, including any documents from the record that are relevant to the court's consideration. And particularly when a trial prosecutor has, or and a trial defense attorney have worked hard on a case, it is really, really helpful to the appellate court to include a supplemental record appendix with any documents that are not in the record appendix.
Yes, Your Honor, and I'm happy to file a copy of that motion to eliminate and the
Why don't you do this? After argument, speak to defense counsel, see if you can agree that those documents are what they are, and jointly agree they can be submitted to the court. And if so, file it. If not, you can file a motion.
Yes, Your Honor.
So just to be clear, the Commonwealth expected that the first complaint witness was going to be the oldest sister, and they weren't going to introduce any evidence about her telling the mother?
That's correct, Your Honor.
Correct. So this was a surprise when she testified, I told my mom first, and I understand you have a different perspective on what she meant by that, but so this was a surprise. She says, well, I told my mom, then I told my oldest sister. And okay. So that's interesting.
Yes, and you can note that at both the motion and eliminate stage and when this testimony was admitted, there was no objection from defense counsel. So that this was, kind of unexpected on both sides and also not considered particularly relevant to the trial.
So what happens then when the actual testimony doesn't support your initial position? Because if we assume that the first statement to the mom was the first complaint, then if that's the case, then the complaint to the older sister couldn't be allowed. Isn't that correct?
So there is some case law suggesting that when the first complaint is maybe not a complaint about the actual acts that occurred and really not fleshed out, that we can substitute an alternative first complaint witness. That obviously wasn't done here because there was no indication that it should be. But regardless, I think with the reading of the testimony, first off, his Commonwealth's position is that there was no, even reading this testimony, there was no complaint to the mom initially about the sexual assault. But even reading this testimony, the victim clarifies in the testimony that she first told her older sister. And so the best reading of this is that regardless of whether or not she eventually told her mom, she told her older sister first. And so based on that, the older sister is the proper first complaint witness.
Even though that's not what she said in page 50 of is it page 50 or the transcript? Or she says, I told my mom, then I told my older sister, right? And so you're saying other testimony suggests that she got the order messed up there?
So there's a couple of mentions. But the testimony that I believe Your Honor is referring to is, yeah, I had told my mom, but like I said, he was so nice. We didn't think he would do that because he was such a regular, nice person. She kind of didn't believe me. And then I had told my older sister. Question, who did you tell first, and then it's cut off, and the witness interrupts with, my older sister, yeah. And so based on that testimony, the victim did clarify that the older sister was in fact the first complaint. And I think there's one other mention of the middle sister talking about telling her mom, and that's on transcript page 47, where she says, that's why I was the one to tell my mom first. But she says that in the context of talking about her versus her younger sister, who was the other victim in this case, telling people. And so she's explaining why she and not the younger sister told somebody. And so I think read in context, she clarified on the stand that it was the older sister she was told first. But I think that the Commonwealth's first position, though, is that the proper reading of this is that she told her mom about the ice cream incident and not about the sexual assaults that happened, that were the charged conduct in this case.
It's such a difficult position to make because the actual paragraph that I was thinking about at page 50, I think, comes after like 5 pages of discussion about the assaults, right? And the ice cream incident is pretty far back in time. So I'm not sure how you make that connection that, oh, but what she really was talking about was this thing that she mentioned, 15 minutes ago.
So I think the best way to explain this is this testimony came years after the incident, and the middle sister's testimony jumped around to different ideas as the middle sister appeared to be thinking about things and then wanting to share them. And so the testimony wasn't quite following a logical or chronological order of this happened, then this happened, then this happened. And she was commenting back on things that she had said earlier. The ice cream incident is discussed on pages 45 and 46, and they talk about the ice cream incident, and then they talk about the charged conduct in this case for about 2 or 3 pages at most, and then and including some like other clarifications about, I believe, layout of the house and things like that. And then after talking about both of those incidents, the prosecutor asks, and after this happened, did you tell anyone about this? And that's when she said she told her mom. And so the question's not a model of clarity as to which of those is referring to. And so even though the witness could interpret that to mean referring to the charged conduct here, the witness could also interpret that to telling about any of these incidents. And based on her...
But I think Justice Toone's concern, well, I shouldn't state what his concern is, but I think the concern is that you may know that, but the question is, does the fact finder also know that?
Here, where the fact finder is sitting as a judge, I think it's...
Well, that's why I said fact finder and not jury.
Right. Yes, where the judge is sitting as a fact finder, I think the understanding about how a witness is testifying and like following how the witness is jumping around, the judge is probably more prepared to do that than the average juror who does not routinely, sit through trials like a judge does. But in any event, regardless of whether or not that should have been admitted, it did not create a substantial risk of a miscarriage of justice. It was a fleeting comment to maybe telling somebody about this incident who didn't believe the middle child, the older victim. And where a judge is sitting as fact finder, generally, multiple first complaints or multiple complaints, I should say, is not sufficient to create a substantial risk of a miscarriage of justice under Moronga, and I'm not sure I'm pronouncing that correctly, but that's cited in the Commonwealth's brief. So regardless of whether that testimony should be admitted, it's not reversible error. On to the second issue, the testimony that was admitted through the officer. It's not quite clear what testimony defense counsel is challenging, but my best guess is the testimony that's being challenged is when the detective says in like one short statement that she went to the hospital, the same interview, and took photographs. At that point in the trial, the fact that the victims had gone to the hospital had already come out through both victims' testimony. The fact that the victims had attended SANE interviews, although they weren't called SANE interviews, had already come out when defense counsel on cross-examination had asked the victims to impeach them, had asked the victims details about their SANE interview. And although at those points the defense counsel didn't identify it as the SANE interview, a judge is going to know that when you're asking a child victim of sexual assault about, them meeting with someone and being interviewed, they know that that's the same interview. And so that had already come out. On cross-examination, the defense counsel actually explored these topics further by asking more about what steps had been taken in the investigation to call into question the victim's allegations at trial versus what their allegations had previously been. For those reasons, that testimony was properly admitted, but regardless of whether it was properly admitted, it did not create a substantial risk of miscarriage of justice. If there are no further questions.
Seeing none, I'd like to thank counsel for both parties and the cases submitted. We stand in recess. 2 minutes.
All rise, please.